Hello students, your topic for today is marshalling and contribution. So what is marshalling means? Marshalling means to arrange, and the rule is it was first introduced in the Transfer of Property Act under section 56. So section 56 may be explained in the following manner. So the first point is that there must be an owner of two or more properties. Second is he must mortgage two or more of his properties to any person. Third is that thereafter he must sell one or more of these properties to any person other than the one he mortgages the property to. The sale must include at least one property that has been mortgaged by the owner. Fourth is the buyer who of such properties is entitled to have the owner satisfy the mortgage debt out of the property, or the property is not sold him before he purchases the property. This can be subject to a contract stating the contrary. Then the rule of marshalling should not be so exercised so as to prejudice the rights of the mortgagee. Any persons who are claiming under the mortgagee, or any persons who has acquired an interest with consideration in any of the properties. So, in short, the rule of marshalling provides the buyer, in the above case, the right to demand from the owner that the property that should be free from any and all the encumbrances before the buyer purchases the property. Section 81 also adopts the rule of marshalling, but in cases of mortgages. Section 81 may be understood in the following manner: that first, there must be an owner of two or more properties, and he must mortgage these two or more of these properties to any person. Then he must mortgage one or more of these properties to another person. The subsequent mortgagee is entitled to have the mortgage debt of the prior mortgagee satisfied out of the properties that are not sold to him. This can be subject to a contract stating the contrarily too. Similar to section 56, the rule of marshalling here too should not be so exercised so as to prejudice the rights of mortgagee to any person who has acquired an interest with consideration in any of the properties. So, marshalling can be explained by an illustration, that is, if the mortgager mortgages three of his properties, these are X, Y, and Z properties, to whom? To A, and then the mortgagees X and then mortgages X property to B. Now B is entitled to have the mortgager satisfy his debt from the sale proceeds of the properties Y and Z, and only if the said sale proceeds fall short can property X be sold. So in Barnes versus Rector, W mortgaged two of his properties to A and B, the properties A and B to X. W then mortgaged property A to Y and property B to Z. Here all the court held that X mortgages will be a proportionally between properties A and B, and the surplus of A will go to Y and the surplus of B will go to Z. So the doctrine of marshalling is thus based on the principle that a creditor who has the means of satisfying his debt out of the several funds shall not, by exercise of his right, prejudice another creditor whose security comprises only one of those funds. Now, the rule of contribution, it relates to the collective contribution towards a mortgage debt by mortgagors. It gives one mortgager the right to have the other property contribute to the discharge of the mortgage debt. When a creditor has a single claim against several debtors, he can realize the debt from any one of them. But as per the rule of contribution, he can claim contribution to the debt by the other debtors, so that the burden might fall on all equally. The rule is encapsulated under section 82 of TOPA, and it may be divided as per the following. So, mortgage property belonging to two or more persons. This is based on the following essentials. First, a mortgage property must belong to two or more persons based on common loan. Second, each mortgager, in absence to a contrary contract, is liable to contribute as per his share of mortgage. So, for example, X, Y, and Z mortgage their properties to D, mortgaging a common debt. Now, if D can recover the entire debt from the properties that are mortgaged by X, X is entitled to demand Y and Z to contribute their portion of the debt out of their mortgage properties. The Privy Council has lucidly explained it in Kamta Singh versus Chaturabhuj. The Privacy Council held that if a person owns one property subject with the property of other persons to a common mortgage and has paid off the mortgage debt, he is entitled to call upon the owners of the other property to bear their proper proportion of the burden. Then when one property is mortgaged first and then again mortgaged with another property. So when the mortgager has two properties and he mortgages one to secure one debt and then mortgages both to secure another debt. If the former debt is paid out of the former property, each property is then liable to contribute to the later debt after deducting the amount of the former debt from the value of the property from which it has been paid. In Bhora Thakurdas versus Collector of Aligarh, the mortgager mortgaged the village of Kachora to one and Nanand Kishore. He again mortgaged villages Kachora and Agrona to Nanand Kishore. The plaintiffs purchased the equity of redemption from Agrana. The first mortgagees purchased Kachora by a degree. The plaintiffs sued and contended that the first mortgagees were liable to pay the proportionate share of the debt for redemption of the second mortgage. The court held that since the whole of the Kachora was swallowed up by the first mortgagee by the decree, the entire burden of the second mortgage fell entirely on Agrana. The Privacy Council in appeal overruled the decision of the court and held that the first mortgagees would have to contribute to the second mortgage as they purchased Kachora. However, in Shesha Iyer versus Krishna Langer, the situation was quite different. Two properties X and Y were mortgaged to R, and properties X and Z were mortgaged to P. R executed his decree on the mortgage by sale of X. P then sued to enforce his mortgage. However, X has already been sold. P sought to sell Z and also demanded contribution against Y. The court held that if the plaintiffs had brought part of the mortgage property subsequently sold under R's decree, they might, by paying off the debt and saving the property from sale, have acquired a right to contribution by securing a lien on the other property. However, since the plaintiffs did not, no right to contribution arose. That's all. Thank you.